Want to hear a crazy personal injury story? Here we go. This story takes place on November 10th, 1993 in the city of Grand Rapids, Michigan. A man named Richard Overton is ready to take on a massive beer company all by himself. That's right, no big shot attorney, just Richard going pro se, which means he's representing himself in court. It's just him against a team of high-powered attorneys from Skadden, Arps, Slate, Megan, and Flom, one of the biggest law firms around at the time. But Richard isn't backing down. Now, what could make someone want to go toe-to-toe with a beer company, you might ask? Well, Richard has a serious bone to pick. He was convinced that the beer company's ads were more than just catchy jingles and fun visuals. He believed that they were downright dangerous. You've probably seen those commercials, the one where everyone's having the time of their lives and they're on a sun-soaked beach, surrounded by beautiful people, all because of this magical drink in their hand. Well, it's Bud Light, making your wildest fantasies come true. Or at least that's what Richard thought the ads were saying. So what did Richard do? He filed a lawsuit on June 6, 1991, claiming that the beer company was violating Michigan's Pricing and Advertising Act. Richard argued that the beer company's product led to something far worse: addiction, health problems, and emotional distress. He even blamed the commercials for causing him financial loss, asking the court for over $10,000 in damages. So let's get into the courtroom drama. The beer company, of course, wasn't just going to roll over. They filed for a summary disposition, a legal move where they asked the court to dismiss Richard's case before it even got to trial. Their argument? The dangers of alcohol are well known. Everyone understands that drinking too much can lead to serious health problems, and that the company didn't have a legal obligation to point that out in every ad. Now, here's where it gets interesting. The court had to decide whether those fun, carefree commercials were actually dangerous, or if Richard was reading too much into them. The judges looked at Michigan's Pricing and Advertising Act, which is all about making sure companies don't lie or mislead people in their ads. But here's the thing. There's a difference between a flat-out lie and a bit of puffery. Those over-the-top claims that nobody really believes, like when the pizza says that they have the world's best pizza, that's puffery, and it's not illegal. So what did the judges decide? They ruled that the beer company's ads were just that, puffery. They weren't making any factual claims that could be proven false. And as for the dangers of drinking, the court said it was common knowledge. And they cited past cases where courts had ruled that everyone knows that alcohol can be dangerous if not consumed responsibly. There was no need for the beer company to add a disclaimer in those ads warning people of the obvious. In the end, Richard's case was dismissed. The judges agreed with the beer company that there was no duty to warn people about the risks of drinking in their commercials. After all, it's not exactly a secret that alcohol can lead to health problems if you're not careful. The court said Richard's claims didn't hold water, and they granted the beer company's motion for summary disposition. Case closed. So what's the takeaway here? Well, it's a reminder that not everything that you see in an ad is meant to be taken literally. And sometimes, no matter how good your argument sounds in your head, the loss may not be on your side. Richard Overton's battle against the beer company might not have ended the way he hoped, but it sure makes for one heck of a story. What do you think about this story? Leave your comments below. Also, if you've heard of any crazy personal injury stories, leave those below as well. And as always, if you do need an attorney or a doctor for a personal injury case, be sure to contact personalinjuryassociation.com. Stay safe, everyone.